So guys, the appeal court reversal of Omotosho's judgment is on the cards. Nnamdi Kanu committed no crime, so therefore Omotosho had no rights to sentence him to life in jail. In this video session, there are two video clips I'll be displaying here for you guys. The first will be that of Nnamdi Kanu's lawyer telling us that they will head to the appeal courts. The second will be that of Nnamdi Kanu's wife. And the last updates will be the appeal court basis that will guarantee Nnamdi Kanu's freedom. Because Omotosho's judgment is not the end of the road. Don't also forget that Omotosho denied Nnamdi Kanu the access to present his final written address, despite Nnamdi Kanu telling Omotosho to show him in the constitution where it states that Nnamdi Kanu doesn't have the right to give his final address. Omotosho walked Nnamdi Kanu out of the court and delivered judgment in the absence of Nnamdi Kanu, stating that Nnamdi Kanu was rude. Why won't Nnamdi Kanu be rude when you have failed to abide by the principles of the law that guides the judiciary? The appeal court in 2022 vindicated Nnamdi Kanu, stating that Nnamdi Kanu has no case to answer, that no other court has a jurisdiction to try Nnamdi Kanu. And you appear in the Federal High Court and sentence him to life in jail. Under what basis? You are trying Nnamdi Kanu under a very trial that was quashed out by the appeal court in 2022. So therefore, what law are you talking about? What judgment are you talking about, Omotosho? Without wasting much of time, let me allow you guys to watch the two video clips that we have for you today. And after watching these two video clips, we are going to be heading to the appeal court's law surrounding Nnamdi Kanu's release. And these laws will certainly and surely guide Nnamdi Kanu because Omotosho's judgment is invalid.
My people, now good evening. Just because many of you have been calling me, let everybody calm down. We are filing our notice appeal tomorrow. And be rest assured, the judgment is going to be set aside because this is not judgment at all. If you are doubting me, I will get the citizen of the judgment tomorrow. I will give it to you and the record of proceedings. You will now discover that the judge left what issues that we raise. He left everything that we are talking about and be writing another thing. So that judgment, it was predicated on anger. It just, Nnamdi Kanu has insulted me. I will show him that I'm a judge. That's all. That's all. It's not predicated on law at all. A matter that was not investigated, the judge, you rejected the statement of Nnamdi Kanu, the DSS wanted to tender. Now, if a matter that was not investigated, there was no statement, there was no investigation report, on what basis are you giving judgment? Issues of the whole Nnamdi Kanu, you did not even address it. You are talking about bombing Britain, British High Commission, bombing American Embassy. All those things doesn't make sense at all. We are finding our appeal tomorrow. We are going to set it aside. Let everybody calm down. Thank you and God bless you.
In Nigeria, a judge cannot ask a defendant to open a defense on terrorism related charges without reading out the written law under which the court is trying that person. Okay, so the Constitution of the Federal Republic of Nigeria, 1999, as amended, Section 36. I mean, I'm sure that is very familiar to everyone now. It provides that a person shall not be convicted of a criminal offense unless the offense is defined and the penalty prescribed as in a written law. So what Omotosho has done today is a written script for him to read out. Everyone could hear him, everyone could see that he was reading a script handed over to him, and that he could barely read out some of the words in his own very written judgment. How interesting. How interesting. I've had to quickly tweet and post the travesty of justice today. regarding how Omotosho ignored the Constitution's requirement that no one can be convicted under an unwritten or unknown offense. He forced Nnamdi Kanu to take a plea under a repealed law, which Nnamdi Kanu refused. So show me where it is written before I can enter into a defense. And that never happened. Omotosho refused blatantly, flagrantly, to issue written rulings on serious applications. So you could hear him reading, you could hear him counting thousands of lines of hours of accounts. But then he refused to issue a written ruling, which he ought to have done first, but never did. He told Nnamdi Kanu to put all objections in a final address, then blocked the final address. So if you were Nnamdi Kanu, you will be as outraged as Maz was this afternoon. You cannot ask me to put my final address, put it down, write it down, and then you block it. So Nnamdi Kanu has right, is his right, to put a final address down, to write it down. But Omotosho blocked that and decided to read out those nonsense he called counts. And he refused to, first of all, decide whether he...
So guys, let's head to the appeal court basis that will help Nnamdi Kanu secure freedom despite Omotosho's unruly judgments against Nnamdi Kanu in the Federal High Court. 1. If the trial courts made a serious error in law, the appeal courts can overturn the judgments if they find that the Federal High Courts misapplied a law, and indeed Omotosho misapplied a law. Because Nnamdi Kanu was extraordinary rendition back to Nigeria in an illegal way, and he had no right to stand a trial before a court in Nigeria because his international rights was abused, his human rights was being abused. Ignored a relevant law or based the conviction on the wrong legal principle. Examples include charging him under a law that does not apply, using evidence that should not have been admissible, giving a sentence not supported by the Evidence Acts or Terrorism Acts. If any of these errors occasioned a miscarriage of justice, the Court of Appeal can set him free immediately. 2. If the evidence was insufficient. On appeal, the judges re-examine the evidence presented at trial. Kanu can be freed if the appeal court finds that the prosecution did not prove every element of the offense. There were contradictions in witness statements. There was no credible link between him and the alleged crime. If the evidence is weak or inconsistent, the appeal courts can quash the conviction entirely. 3. If his rights were violated. This is a major angle because appellate courts take constitutional breaches very seriously. Kanu may be discharged if he was illegally abducted or forcefully repatriated in a way that violates international law. His rights to fair hearing was breached. He was denied access to counsel, medical care, or documents necessary for his defense. Evidence against him was obtained through torture or illegal detention. If such violations affect the fairness of the trial, the appeal courts can set him free on those constitutional grounds. 4. If the charges were defective. A defective charge automatically destroys a criminal trial. The appeal can succeed if the counts do not disclose an offense, the charge was duplicated, vague, or incompetence. The trial courts lacked jurisdiction. If the charge is legally defective, the Court of Appeal will nullify the entire trial. 5. If the judge's sentencing was wrong, even if guilt was proven, the appeal courts can still free him if the sentence was excessive. And indeed, it is true that those counts read out by Omotosho was excessive because those counts were unnecessary. You arrested Nnamdi Kanu in Kenya, brought him and slammed a 7-count charge on him. Count that shouldn't be placed on him because the appeal court in 2022 stated clearly that no court has the jurisdiction to try Nnamdi Kanu. And this very count that was read out by Omotosho in courts were quashed in 2022 by the appeal courts. So therefore, this sentencing does not stand. Let's continue. The trial judge misinterpreted the sentencing guidelines. The law used to sentence him was not applicable at the time of the alleged acts. This can lead to setting aside the conviction. Well, you have seen, you have heard, you have also read. These are the 5 appeal court bases that will secure Nnamdi Kanu's freedom. Because Omotosho had no jurisdiction to try Nnamdi Kanu. Omotosho had no jurisdiction to arraign Nnamdi Kanu before his very self. And Omotosho even walked Nnamdi Kanu out during the court trial. He slammed out a judgment on Nnamdi Kanu in his absence. This is nothing but wickedness. And I must also call out Awomolo. Awomolo, who is the late counsel representing Tinubu and the federal government, worked tirelessly to ensure that Nnamdi Kanu is being jailed. Imagine that Awomolo seek a death penalty for Nnamdi Kanu. But it was Omotosho in his own jurisdiction that reduced the penalty to a life imprisonment. But still, these were the wrong sentencing. These were the wrong judgments. And this was injustice against humanity. Not only against Nnamdi Kanu, but also against the Igbos. Because these very judgments was a slap on the Igbos. Because Nnamdi Kanu committed no crime. Because if he committed a crime, the Kenyan High Court would have punished him. But instead, the Kenyan High Court vindicated him, stating clearly that Nnamdi Kanu was innocent and he had no case to answer. At this point, I'll let you guys tell me what you feel about this in the comment section below. Do well to like this video, do well to share this video, and do well to hit the subscribe button below for more trending updates.